Good day, everyone. For this video discussion, we are going to tackle Chapter 6, the Rescissible Contracts, that covers Article 1380 to 1389. So by the way, I am Glea Fernolias, and I am going to share Articles 1380 to 1383. So to start, Article 1380 states that contracts validly agreed upon may be rescinded in the cases established by law. So these cases will be discussed further in the following articles. But before that, let us first know what rescissible contracts and rescission is. So, rescissible contracts are contracts which are validly executed but may be set aside for equitable reasons. So, rescissible contracts valid because all the essential elements for validity are present: the consent, object, and the cost, but are defective due to lesion or what is known as economic damage or the fact that the price is unjust. Next is recession. So, recession is the remedy granted by the law to the contracting parties and even to third persons to obtain reparation or damages caused to them by a contract. So, even if the contract is valid by means of the restoration of the things to their condition to perfection of the contract. So, recession in general is a remedy allowed by law for the reparation of damage by a contract through restoration of things, so to the condition prior to execution of the contract. And to avoid avail the remedy of recession, the requisites are the following. First, the contract must be validly agreed upon. Next, there must be a lesion or pecuniary prejudice or damage to one of the parties or to a third person. Then the recession must be based upon a case especially provided by law. And then there must be no other legal remedy to obtain reparation for the damage. Next, the party asking for recession must be able to return what he is obliged to restore by reason of contract. Next, the object of the contract must not legally be in the possession of the third persons who did not act in bad faith. And lastly, the period for filing the action for recession must not have prescribed. But don't be confused because we have rescission under Article 1380, which is under our topic for today, and rescission of an obligation under Article 1191. So, to clearly understand, let us differentiate the two articles. Under Article 1380, rescission is based on lesion or fraud. But under Article 1191, it is based on the non-performance or non-fulfillment of the obligation. Another difference between the two is that the action is instituted by either of the contracting parties or by the third person. So the injured party or the third person may bring action who suffered lesion or fraud. In Article 1191, the action may be instituted only by the injured party to the contract. This means that the only party who can bring the action is the injured one. So, then lastly, in the Article 1380, the court cannot grant a period or term within which to comply. And in rescission under Article 1191, in some cases, the court may grant a term. Next is the Article 1381, which enumerates the five types of rescissible contracts. The first is those which are entered into by guardians whenever the wards whom they represent suffer lesion or by more than one-fourth of the value of the things which are the object thereof. Second, those agreed upon in representation of absentees if the latter suffered the lesion stated in the preceding number. Third, those undertaken in fraud of creditors when the latter control in any other manner collects to the claim due them. Fourth, those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority, and lastly, all other contracts especially declared by to the subject to rescission. So let's discuss the first paragraph. So it states that those which are entered into by guardians whenever the ward whom they represent suffer lesion by more than one fourth of the value of the things which are the object thereof. So the contracts referred to here are those entered into by guardian without the approval of the court in the management of the property of the ward. So if the contract is within the approval of the court, there can be no rescission regardless of the lesion. So an example situation is given below. So Joanne is the guardian of Mark or the ward. Then Joanne sells the property of Mark worth 20 million for only 14 million. So the contract of sale here can be rescinded because the lesion is more than one fourth, and Mark can rescind the sale by proper action in court upon reaching the age of maturity. Next paragraph are those agreed upon in representation of absentees if the latter suffer their lesion stated in the preceding number. So an absentee is a person who vanishes from his residence, his whereabouts are unknown, and without leaving a representative to govern his property. So, similarly, the absentee must suffer loss of more than one fourth of the value of the contract's property object to be entitled to rescission. So, an example situation again is given below. So, Wendell, the owner of a resort in Laguna, left his property without notice and without leaving a representative to take care of his property. So Bea, a family friend, volunteered in taking over Wendell's business due to a storm. Wendell's business is greatly affected due to the destruction of some buildings of the resort and needs additional funds to recover from such distress. So, and Bea decided to sell one property of Wendell worth 15 million and sold it for only 10 million. In this situation, when Wendell returned, he can rescind the contract of sale made by Bea because the lesion is more than one fourth. So take note that paragraphs 1 and 2 refer only to transactions by guardians and absentees representatives. So in third paragraph, so those undertaken in fraud of creditors when latter cannot in any other manner collect the claims due them. So paragraph 3 has the following requisites. So first, there must be an existing credit prior to the contract to be rescinded, although it is not yet due or demandable later. Next is the subsequent contract made by the debtor conveys a patrimonial benefit to a third person. Third, there must be a fraud on the part of the debtor which may be presumed or proved. And fourth, the creditor has no other legal remedy to satisfy his own claim, that is, he cannot recover his credit in any other manner, it not being required that the debtor be insolvent. So say for example, Mary made a donation of a parcel of land to Red. So before the date of the donation, Mary had contracted several debts. So with the donation to Red, the remaining property of Mary is not sufficient to pay all her debts. So the donation can be rescinded because the alienation is presumed in fraud of creditors. So the fourth paragraph, those which refer to things under litigation, if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. So, by the way, litigation is a term that applies to a legal dispute where two or more parties are seeking monetary damages. So the objective is to render a party litigant's claim over an item under litigation that was the subject of a contract entered into by the other party with another person effective. So next, um, say in fourth paragraph, for instance, Mandy sues stand for the recovery of a parcel of land. So in this case, the thing or the land is a thing under litigation. So if during the pendency of the case, then sells the land to Rain without the approval of Mandy or of the court, the sale is rescissible at the instance of Mandy in case he wins in her suit for recovery of said land unless Rain is in legal possession of the land in good faith. So Mandy, however, may protect his right by filing a notice of his lease pendants or which means a formal public notification that a lawsuit involved a property claim has been filed. So lastly, all other contracts especially declared by law to be subject to rescission. So moving on to the next article, Article 1382 states that payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were affected and are also so there are two conditions that must concur for concur for the article to be applicable. So first, the debtor must be in the state of insolvency, and insolvency need not be judicially declared. Then next is the payment exacted from him is for a debt not yet due and demandable. So these both conditions are required for us to say that it is rescissible. So if payments made in insolvency and yet you pay for your debt and it is not yet due and demandable, so that makes the contract rescissible. Next is Article 1383, which states that the action for rescission is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. So rescission here under 1380 is a subsidiary action, meaning the injured party cannot claim rescission at the first instance and he must resort to his other available remedies before he may invoke rescission. So, in other words, the injured party must have no other means by which to obtain reparation because rescission under Article 1380 is a subsidiary action only. So, the next article will be discussed by Jane Kaintig. That's all for today, and thank you.
Hey everyone, I am Jane IVD Kaintik. I am the reporter of Article 1384 to Article 1386. So, our Article 1384 states that rescission shall be only to the extent necessary to cover the damages caused. The entire contract need not to be put aside by rescission if the damage can be restored or covered by partial rescission. So, the only purpose of rescission is to repair or cover the damages caused. Complete rescission will not be allowed if it is not justified by the circumstances of the case. So, for example, C, the guardian of D, a minor, was authorized by the court to sell two parcels of land valued at 200,000 pesos each. However, C sold the two parties to E for only 200,000 pesos. So supposedly, it should be 400,000 pesos since two parcels of land times 200,000 pesos each. So that would be 400,000 pesos. So the sale of that one parcel of land is valid already. So there's no way that D will claim for the rescission regarding that land. So in this case, the entire contract need not to be rescinded since one of the parcel of land was paid for its right amount, which is the 200,000 pesos. Rescission may properly be applied only to one parcel to cover the damage caused by C. But if C, the guardian of D or E is willing to pay the difference of 200,000 pesos, then rescission is prevented from happening. Under Article 1384, it also states here that only the creditor who asks for the rescission benefits from the rescission, and those who are strangers to the action cannot benefit from its effect. Next article is Article 1385. So the main idea of this article is that when there is a rescission, so make sure to return whatever you have received by virtue of contract. So, mao ni siya ang provision sa 1385. So the effects of rescission, we have the obligation of mutual restitution, abrogation of contract, and the obligation of third person to restore. So first, we have the rescission creates obligation of mutual restitution. So there is no obligation to restore if nothing has been received. So there is a need to return to each party first the object of the contract with its fruits, and second is the price with the legal interest. So for example, in a contract of sale rescinded by the buyer, so the seller has the obligation to return the purchase price or the amounts that was being received plus the legal interest from the date he received the notice of rescission up to the date of return. So rescission is the unwinding of a transaction. So the purpose of rescission is to bring back the or bring the parties back to the position in which they were before they entered into a contract. Second effect is that the abrogation of contract. So when a rescission is granted, it has the effect of abrogating the contract in all respects. So it's like um, cancellation of contracts na. If there is a rescission. We also have the transfer to third person. So there are two circumstances wherein the effectivity of the rescission will be greatly affected. First, it is when a property had already been transferred legally to a third person. And second is that the third person did not act in bad faith. And lastly, we have the obligation of a third person to restore. So, rescission also applies to a third person. Of course, if the third person has nothing to restore, then this article does not apply. If a contract is rescinded on the ground that it has been entered into a fraud of creditors, the plaintiff creditor has no obligation to return anything since he has received nothing. Next topic is about the when is rescission not allowed. So we all know that mutual restitution is required in rescission, and this presupposes that both parties may be restored to their original situation. So like ilang ipanghatag kung unsa to ang mga nahatag na nila as they do the contract. So the remedy of rescission cannot be availed of since those who demand cannot return under contract. So kung walay mahatag, then rescission cannot be allowed. So for example, C, the guardian of D, which is a minor, sold to M the land for 160,000 pesos, even if the true value of that land is 200,000 pesos. So upon reaching the legal age, D can ask for the rescission of such contract. If the contract is rescinded, so M must return the land with the fruits received by him plus the legal interest from the date of action. However, if M cannot return the price with the corresponding interest, then he cannot rescind the contract. Another example is that A sold to B a piece of land in fraud of his of his A's creditors. So as A sold it to B, B took the legal possession of land already. So the question is, may the sale to B be rescinded? So the answer would be depending on whether B has acted in good faith or in bad faith. So if B was in good faith, So rescission cannot take place because the object of the contract is legally in the possession of a third person who did not act in bad faith. However, if B was in bad faith, then rescission is proper. Next article would be Article 1386. Rescission referred to in numbers 1 and 2 of Article 1381 shall not take place with respect to contracts approved by the court. So, if a contract entered into behalf of a ward or absentee and then it has been approved by the court, rescission cannot take place because it is valid whether there is lesion or not. These are contracts entered into by the guardian or the representative where the ward or the absentee suffers a lesion of more than one-fourth of the value of the property. So, if the contract is approved by the court, then rescission cannot be availed even if the lesion of more than one-fourth of the value of the property be suffered by the ward or the absentee. So, for example, Gardo is a guardian of Mirna who is a minor. And then Gardo sells the 20,000 peso worth property of Mirna only for 15,000 pesos. So, in this example, the contract of sale cannot be rescinded because the lesion is not more than one-fourth unless the contract of sale is approved by the court. However, if the property is sold for less than 15,000 pesos, then Mirna can rescind the sale by the proper action in court upon reaching the legal age. So that would be all for my part. Thank you.
Hi everyone, I'm Jean Redoble, and let's now proceed to Article 1387 under Recession Contracts. Flashed on your screen is the provision. Article 1387 establishes presumptions of fraud in the case of alienation by the debtor of his property. However, the instances mentioned are not exclusive of others that may be proved in any other manner recognized by the law of evidence. The presumption in Article 1387 applies only when there has in fact been an alienation or transfer, whether gratuitously or by onerous title. The effect of the presumption is to shift the burden to the one who alienated to prove that the transfer was not fraudulently made. Under the Civil Code, only actual creditors can ask for the rescission of the conveyance made by their debtors in favor of strangers. The waiver and release made previously by the creditor of the credit he held against the debtor operate to deprive the rescissory action of any legal basis. An action for rescission of sale under Article 1387 cannot be finally determined without the presence in court of the vendor, for any decision on the action or claim for damage would affect him. He is entitled to be heard. When alienation presumed in fraud of creditor. When we say alienation, it is actually means the transfer of property as by conveyance or will into the ownership of another. And I think you guys already know what fraud is. It is actually the any intentional act or omission designed to deceive others, resulting in the victim suffering loss or the perpetrator achieving a gain. This provision establishes prima facie presumptions of fraud in the case of alienation by the debtor of his property. The general rule here is that fraud is not presumed. As fraud criminal in nature, it must be proved by clear and preponderance of evidence. When we say prima facie, it is the legal claim that has sufficient evidence to proceed to trial or judgment. So we have alienation by gratuitous title. When we say gratuitous title, these are donations and testate and intestate succession. For instance, let's say Riza donated a parcel of land to Emily on June 15, 2020. Before that date comes, Riza had contracted several debts. With a donation to Emily, Riza becomes insolvent. The donation is presumed fraudulent unless proved otherwise. We also have alienation by onerous title. When we say onerous title, these are the title to the property acquired by giving valuable consideration. Let's say the contract is a sale. Under the second paragraph, the sale is not presumed fraudulent. The creditor must show that the conveyance will prejudice their rights. However, the presumptions of fraud will arise in case the sale was made after some judgment has been issued against him. And suppose the creditor has obtained a judgment or writ of attachment in his favor. And when we say writ of attachment, it actually means that the form of prejudgment process in which court orders the attachment or seizures of property described in the writ. For instance, let's say Riza, again, sold a parcel of land to Emily. Before the sale, Riza had contracted several debts. Because of that sale, she became insolvent. The creditors of Riza must show that the sale occurred resulted to an unfairness to their rights. In this case, fraud will arise only after some judgments have been made to Riza that has been issued against her. In the consideration of whether or not certain transfers are fraudulent, courts have laid down certain rules by which the fraudulent character of the transaction may be determined. Some of the circumstances are it is flashed on your screen. First is the fact that the consideration of the conveyance is fictitious or inadequate. Second, a transfer made by a debtor after suit has begun and while it is pending against him. Third, a sale upon credit by an insolvent debtor. Fourth, the transfer of all his property by a debtor, especially when he is insolvent or greatly embarrassed financially. Fifth, the fact that the transfer is made between a father and son when there are present some or any of the circumstances mentioned. Sixth, we have the failure of the vendee to take exclusive possession of all the property. And lastly, when it was known to the vendee that the vendor had no properties other than that sold him. So, what really are the effects of fraud? Actually, the existence of fraud does not make the alienation rescissible whether the fraud is presumed or proven. If the transferee acquired the thing in good faith and for valuable consideration, even if the debtor who made the alienation act fraudulently, rescission will not be allowed. And now, let's proceed to Article 1388 of Rescission Contracts. Flashed on your screen is the provision. And as you can see, and if you're going to read it, it kind of interpret that the first to be able to get the property is the one being liable. So, liability of purchaser in bad faith. The purchaser in bad faith who acquired the object of the contract alienated in fraud of creditors must return the same if the sale is rescinded, and should it be impossible for him to return it due to any cause, he must indemnify the firmer. When we say bad faith, it does not simply connote bad judgments or negligence. It imports a dishonest purpose or some moral obliquity and conscious doing of wrong. It means there is a breach of a known duty through some motive or interest, or could also be ill will. It partakes of the nature of fraud. Bad faith actually is a state of mind indicated by acts and circumstances and can be demonstrated not only by direct proof but also by circumstantial evidence. For instance, let's say Sabrina sold her van to Bernadette to avoid paying her debt to Colby. Bernadette knew that the purpose of Sabrina. In case of recession, Bernadette must return the car. In case that the car has been destroyed, Bernadette is obliged to indemnify damages suffered by Colby. So, what is the liability of a person who, being aware of the intention of the debtor to defraud his creditors, still insisted on acquiring or purchasing the debtor's property? Actually, the person will be liable to return the property to the particular creditor or creditors who had successfully instituted the complaint for recession. And now we'll be going to Article 1389 of the Rescission Contracts, and flashed on your screen is the provision. So here, the general rule is that the prescriptive period within which to file a rescissory action is 4 years. The reckoning time, however, may vary depending upon the circumstances. So it could, if the complaining party is a third person who has no participation in the contract, the prescriptive period is 4 years reckoned from the discovery of the fraudulent contract or from the registration thereof if real property is involved. While if the complaining party is a minor or people under guardianship, the action to rescind must be done within 4 years after attaining the age of majority. And if the complaining party is an absentee, he should file an action for recession within 4 years from the time his domicile has been known. An absentee is one who has disappeared from his domicile and his whereabouts are unknown without leaving an agent to administer his property. Consequently, when she appears in his domicile, he ceases to be an absentee as long as he informs the court of his presence. The action for recession may be brought by, first, it could be the injured party or the fraudulent creditor. Second, it could be the heirs, assigns, or successors in interests. And it could also be the creditors of the above entitled to subrogation. And that's all for the recession of contracts. Thank you.